Hello, we're going to discuss venue. We're going to discuss forum nonconvenience, and we're going to discuss the Erie doctrine. Okay, first of all, venue. All right, venue for an initial filing. Okay, our rule from 26 USC 1391. What's that statute again? 1391. Hey, what's the statute for supplemental jurisdiction? That's right, 28 USC 1367, A and B. Okay, proper venue. Any district where all defendants reside, so long as all reside in the same state. 2, any district where a substantial part of the events or property giving rise to the claim occurred. Or our fallback venue, anywhere the defendant is subject to PJ. What's proper venue for an initial filing? 1, any district where what? All defendants reside. If what? They all reside in the same state. What's our second prong here? Any district where a substantial part of the actions, property, or omissions giving rise to the claim occurred. And then we have our fallback venue. What's that? Anywhere the defendant is subject to PJ. Okay, so can you transfer venue from state court to state court? No, you can't. Those are different judicial systems. Can you transfer from federal court to federal court? Yes, that is what we are talking about. Okay, so let's talk about transfer of venue. Transfer of venue. Defendants can remove to a proper venue. And what is a proper venue? It is one that has PJ over the defendant and venue hasn't been waived, and it's a proper venue in the first place. So a court may grant transfer based on convenience of the parties and interest of justice. A court may grant a transfer of venue based on the convenience of parties and the interests of justice. Okay, so the transferor court has to be a proper venue in the first place, have PJ over the defendant, and nobody can have waived venue. And if so, the court may grant the transfer based on what? That's right, the convenience of the parties and the interest of justice. Okay, or to any state where all the parties agree and the court consents. Okay, so that's rare. But if all parties agree and the court consents, then you can transfer venue there. Okay, so there are public and private factors that govern transfer of venue. There are 3 public factors. Having local matters decided locally. Local matters decided locally. The administration of justice and the applicable law that governs the action. Think of Piper versus Reno. Scotland was the appropriate forum. So those are our 3 public factors. Our 2 biggest ones are what? That's right, court may grant transfer based on, that's right, convenience of the parties and interests of justice. Based on the public factors, 3 public factors, local matters decided, that's right, locally. The law applicable that governs the action, Piper versus Reno, and the administration of justice, the availability of the court. And our private factors, this comes to us from Piper versus Reno, where the witnesses are, where the evidence is, or to any state where, that's right, all parties agree and the court consents. Now, we talked about a proper venue. What about an improper venue? If we originally removed and that venue is improper, the court may transfer in the interests of justice or dismiss the case. Okay, so if the transferor court is an improper venue, the courts may do what? Transfer, that's right, in the interests of justice, or they can, that's right, dismiss the case. Okay, so let's go through that one more time. Where, good, all defendants reside, any district where a substantial part of the claims, omissions, evidence, events, a substantial part of the claim arose, or our fallback venue, anywhere where the defendant is subject to PJ. Okay, so we could, where the courts are going to transfer based on two factors. What are they? That's right, convenience of the parties and the interest of justice. Or two, any state where the parties agree and the court consents. What happens if we filed in an improper venue? The court may do what? Transfer in the interest of justice or dismiss the case. Okay, by the way, from conflicts, remember that forum selection clauses are generally enforceable. Now, finally, let's look at those public and private factors. Okay, so we call this, where is the center of gravity of the case? Remember, it's convenience of the parties and interests of justice. Where is the center of gravity of the case? Public factors. We want local matters decided locally. We want to have the applicable law there. Availability of the court, and the private factors, where the witnesses are, where the evidence is. Okay, next up, forum nonconvenience. Forum nonconvenience means dismissal. It means that litigation does not belong here. The court is going to dismiss something based on forum nonconvenience because another court would be a proper venue. Okay, this often comes up when the center of gravity court is in another country or another, at the state level, in another state. Okay, so the adequate alternative inquiry test. Okay, so why shouldn't we dismiss this case and transfer it? Well, the defendant must offer an alternative court that is able to hear the case, which two, must have the ability to provide a remedy to the plaintiff. Adequate alternative inquiry. Okay, so we're asking for a dismissal because that litigation doesn't belong here. It doesn't belong in Missouri. It belongs in Illinois. So the defendant must offer an alternative court that is what? Able to hear the case and the ability to what? That's right, provide a remedy to the plaintiff. Moving on, we're going to discuss the Erie doctrine. Okay. A federal court sitting in diversity applies the substantive law of the state in which it sits, including its choice of law rules and federal procedure. That's our Erie doctrine. A federal court sitting in diversity will apply the substantive law of the state, including its choice of law rules and federal procedure. Okay, so here are our questions. Is there a federal directive, law, or provision on point, squarely on point, that clashes with the state law? Well, what law would we apply? That's right, federal law, supremacy clause. Federal law trumps state law. Is there a federal provision squarely on point? Apply the federal law. Okay, then what if there is no federal provision squarely on point? What must the federal judge do? They apply state law, state substantive law. So, what is substantive? Statutes of limitations are substantive. Choice of law is substantive. Okay, and it's also, of course, to avoid forum shopping. Okay, and the other test we have is outcome determinative. Okay, would the law, if a federal judge sitting in diversity applies the state substantive law. What's substantive? Choice of law, statutes of limitations. And we're going to ask ourselves, would the law be outcome determinative? Would using that state law be outcome determinative? Okay, more about that in a bit. Okay, so the twin arms of Erie are to avoid forum shopping and avoid the inequitable administration of law. Okay, so that's the end of this. That's the basics, and we'll get into outcome determinative in a minute.